Welcome back to the noon hour at Law and Crime. I'm Judge Ashley Wilcott. I will be with you today from noon to 3. We are going to go right back into trial to hear closing arguments. This was a defense motion to not allow a detective to testify as an expert witness. And again, this is the case of New Jersey versus Jeremiah Monell. Let's see what their closing arguments consist of. Well, I'm impressed with this judge. He is rattling off all of the things that defense has argued and what his response is, although we don't know the ultimate ruling yet. Let me introduce our very special Law and Crime analyst as well as commentator, Elura Nanos. Thank you for being with us today.
Thanks so much.
And so let's talk about here what the judge is saying, and I understand it to be saying is, I now have to decide whether or not he can be qualified as an expert to testify about the bloody palm print on the knife. Is that your understanding, first step of what the judge has to decide?
Yes, of course. And a ruling that this witness can testify as an expert really is about whether or not the witness can give his opinion about something. This investigator, I believe, is also a fact witness, so there should be no problem with him testifying about facts that he personally observed, but whether or not he'll be allowed to testify about his opinion of things, that remains to be seen.
Okay, let's break it down a little bit further for the viewers. So the judge has already said, listen, the defense basically had two arguments. One is that it was a net opinion offered by the detective, and number two, that the procedures used suggested a result were too suggestive and that therefore shouldn't be allowed. But the judge is now talking about procedures that are generally accepted. So tell me, generally, my understanding in being a judge and hearing all the experts testify, if it's a procedure that's generally accepted and shows within a reasonable degree of probability, then it's going to be allowed. What's your opinion?
Absolutely. I mean, it's all about, is the science or the procedure that's being used something that is usually used and usually relied on by experts in this particular situation? And
so would you expect, before we get to what the judge's ruling is, would you expect him to allow this testimony as expert testimony or not?
I would absolutely expect that this judge is going to accept that as expert testimony. I don't see any issue with this guy being qualified as an expert, and that tends usually to be the case anyway. So I would certainly expect it here, and it is also usually the case.
All right. And so Laura is absolutely correct, because we now know that the judge has ruled that he is going to allow this testimony, expert testimony by the detective in this case. And again, it's really a crucial point for the prosecution, because this is about a palm print of the defendant left on one of the bloody knives used to stab to death. We are going to take a short break, but come back with us and we'll return to this trial. Welcome back to Law and Crime. I'm Judge Ashley Wilcott. Happy that you're joining us. We're covering our first live trial of 2019. This is New Jersey versus Jeremiah Monell. He is a defendant in this case, accused of killing his estranged wife. Now, one of the things I want to talk about is earlier in this case, in some pretrial motions in December, he had said he was not happy with the services of his public defender attorney, and he told the judge he had complaints, didn't want that attorney. The judge basically said, well, talk to the public defender's office, because that's who you need to take that up with. Fast forward to today, trial starts. He refused to come into the courtroom. The judge's decision was, even if you don't come to court, we are going forward with this trial. We will let the jury know. We will read a statement, but we're going forward. He is in the courtroom, so we don't know exactly what his position was, why he didn't want to be there, what he had an argument about his attorney doing, but he was unhappy with something, but he is in the courtroom. So, Laura, let's talk about this. What happens when a defendant says, I'm not coming to court, I don't want to be there? Is that a reason that a judge should stop a trial?
Well, certainly the judge should attempt to do all that's possible to get the defendant in there. But ultimately, if the defendant chooses not to be in the courtroom, the defendant can be tried in absentia. It happens all the time. We see this kind of behavior where we see someone just being belligerent, refusing to come out into the courtroom, refusing to cooperate with his own counsel. And basically, the criminal justice professionals do their best to make sure that someone is included in their own defense. But at some point, if the person refuses, they refuse.
And so let's talk about his behaviors. He has been described as belligerent to the court about his attorney not wanting to come to court. At what point as a defense attorney do you think someone should say, wait a minute, is there something else going on mentally? Do we need to explore whether or not there's an insanity defense or whether or not he's competent to stand trial?
Yeah, I think that that's a very good point, because we're seeing here signs that maybe something is not quite right. We saw that this defendant was offered what would probably be a pretty good plea deal. He didn't accept it. We saw that he said he was unhappy with his counsel. We see that he's not being cooperative with his own defense. And these are pieces that kind of come together that should make a defense attorney think, perhaps there's something here, something mental health-wise going on. But of course, as you know, just the fact that someone may have some mental health issues doesn't mean that they're not competent to stand trial, doesn't necessarily mean that the facts are there for an insanity defense. So there may not just be enough.
And we're going to explore that more later. Right now, we're going to return to court where the judge is reading jury instructions to the jury for this trial to get underway. So there you've heard the judge giving jury instructions to the jury for the start of this case. Now, I have to ask you, Elura, I really am happy to hear the way the judge is doing it, because I find he's very normal. He's just explaining in plain English. Who cares if you think that I have feelings about this case? I don't, but if you think I do, ignore him, because you're the one making the decision. How did you feel about his remarks to the jury in the instructions?
I could not agree more. I think this judge is doing a fantastic job explaining what he means. And, you know, sometimes I think judges, when giving jury instructions, because they say the same thing over and over, they can kind of get lost and not realize that it sounds like jargon. I think this judge is doing really an outstanding job making sure that he's heard and understood.
I agree. And the other piece of it that I really liked is the fact that he talked about social media, and he didn't just say avoid social media or don't use it. He said, look, I know that it's going to be tempting. You may see something come across your feed, but it's your obligation to avoid it. Now, today's day and age, do you really believe that jurors really avoid social media about a case that they may be sitting on as a jury member?
Oh, I think they may. I think that we are now so accustomed to social media that it is possible for us to, you know, see a headline and then say, I'm not going to continue to read that, or I'm not going to click in it. I doubt this is the kind of case where, a juror is going to see every single person in their feed posting over and over again on it. Maybe they would see one headline, and likely the headline would just be something to indicate the subject matter, and they would choose maybe not to click on or not to read what the person posted. So I do think we're getting kind of more savvy with the use of social media, that if something kind of did creep in there, we might be in a better position to just ignore it.
And I know I've seen as a judge, jury members really take it seriously. I believe in our system. I believe in the jury system. And they, in general, take it very seriously, follow the rules. And I've also seen jury members report anyone else on the jury that's doing something they shouldn't, or looking at online, or says, ooh, I talked to my mom about the case last night and here's what she thought. So I really am confident that that does happen when there is any, whether it's inadvertent or purposeful, discussion of the case. What's your experience?
I agree, and I think that in a case like this, which is a brutal murder case, I think that we'd be hard-pressed to find anyone that wouldn't take their obligations very seriously. These people understand this is important. They understand that their role in this process is important. They understand that this is high stakes, and I think that most people would do everything they can to follow a judge's orders, to do things by the book, and to do that, in a way that doesn't sacrifice any part of our justice system. So I expect that these people are going to do their job.
Yeah, absolutely. So we are going to continue covering this case live today on Law and Crime after this break. Welcome back to Law and Crime. I'm Judge Ashley Wilcott. Well, let's first start with the live trial that we have been covering. This is New Jersey versus Jeremiah Monell. This is the one in which the judge has instructed the jury so that they can get started with trial. The judge did rule that the detective will be allowed to testify as an expert about a bloody handprint that was found on one of the two knives used to stab his estranged wife in this case. Now, they are on a lunch break. They will resume, or they've announced They'll resume at 1:30 p.m. Eastern Standard Time. We all know that sometimes that exact time line isn't adhered to, but we will cover that trial as soon as they do return from lunch. Now, in the meantime, we have some different packages to share with you, and this is one that's going to be a fascinating trial upcoming in 2019. It's the Uber case. Let's hear more about that.
A former Michigan Uber driver could get life in prison for a 2016 shooting rampage that left 6 people dead. Prosecutors say Jason Dalton killed 6 and critically injured 2, including a teenage girl. The frenzy began while Dalton was transporting a passenger from Kalamazoo College. Dalton claimed he began seeing strange symbols on his phone, and a sensation came over his body. He began driving erratically through the streets, frightening the rider, who was eventually able to escape. Dalton told police he drove back to his home and began preparing his weapons. He said he drove to an apartment complex intending to pick up a rider. Instead, he found 25-year-old Tiana Carruthers. Dalton shot her multiple times. Tiana managed to survive. Dalton continued, reportedly fatally gunning down 53-year-old Richard Smith and his son, 17-year-old Tyler Smith, at a car dealership around 10 p.m. The final shooting occurred less than 20 minutes later, when Dalton allegedly shot 4 women and a young girl in a Cracker Barrel parking lot. Sisters-in-law Mary Lou and Mary Jo Nye, Dorothy Brown, and Barbara Hawthorne were among the dead. Barbara's family friend, a 14-year-old, sustained a gunshot wound to the skull, but managed to survive. In interviews with police, Dalton said it was like it wasn't even himself. He further explained to a psychiatrist, "It almost seemed like my phone could control me," despite reportedly having no history of psychiatric delusions. In spite of his claims, he was found competent to stand trial in April 2016. An appeals court threw out the confession Dalton made to police, citing Miranda violations. Dalton pleaded not guilty to the charges. His defense attorney has expressed intent to use an insanity defense. Dalton faces 6 counts of murder, 8 weapons charges, and 2 counts of assault with intent to murder. For the Law and Crime Network, I'm Aaron Keller.
Well, it's always sad when a victim's been murdered, but I think it's even more tragic or harder to comprehend or understand, and how can you possibly prevent when these victims were innocent victims, 6 individuals killed, 2 injured, that were just doing their normal everyday activities. So let me ask you about the fact that he says his phone had symbols, maybe told him to do it, and then from there he went back, prepared his weapons. Is that premeditation, or is that a valid insanity defense?
At this point, it could be either. I think it's too early to say. Certainly the fact that there was things leading up to this killing, it didn't happen just in the moment, that does tend to prove premeditation. On the other hand, if it turns out that he can prove that he had a mental defect and that it met the standard for not guilty by reason of insanity, it is possible that that's what this will do. But I think just judging from just the news reports and the little bit we know right now, it's really too early to say that. But I think that either way, what happened leading up to these killings is going to be critically important.
Yeah, absolutely. So now we're going to look at 2019 and other trials that we can expect to see this year on Law and Crime.
I'm Anthony Velez, and here are the top upcoming trials of 2019. The quadruple homicide trial of Charles Chase Merritt, the man accused of fatally beating a business associate, his wife, and their 2 preschool children, is set to begin on January 7, 2019. The 61-year-old suspect is facing charges in connection to the disappearance of business associate Joseph McStay, his wife, Summer, and their young sons, 4-year-old Gianni and 3-year-old Joey Jr., from their home in Fallbrook in 2010. The family's remains were discovered in the Mojave Desert in 2013, and Merritt was arrested in 2014. Merritt represented himself for a short period, but later sought legal assistance. Merritt now faces the death penalty if convicted. The trial of the retired Tampa police captain who claims he fatally shot another man in self-defense during a dispute at a movie theater is scheduled to begin on February 25, 2019. 75-year-old Curtis Reeves reportedly fatally shot Chad Olson inside the Cobb Grove 16 after the 2 men argued over Olson's use of a cell phone during previews. Olson allegedly approached Reeves and threw a bag of popcorn at him before Reeves drew his gun and fatally shot Olson. Reeves tried to claim a stand your ground defense, but a judge rejected the defense argument, and that decision was upheld on appeal. His defense team will reportedly argue self-defense at trial. Reeves is now facing a second-degree murder charge. The trial of the Georgia man accused of killing an 11th grade history teacher in Ocilla is set to begin in April 2019. The defendant, Ryan Duke, was arrested in 2017 in connection with Tara Grinstead's 2005 disappearance and death. Duke and another man, Bo Dukes, reportedly told friends at a party a month after Grinstead's disappearance that they killed Grinstead and burned her body. Duke now faces multiple charges, including felony murder. Bo Dukes faces charges of concealing a death, tampering with evidence, and hindering the apprehension or punishment of a criminal. A man accused of killing his pregnant ex-girlfriend and a police officer who tried to arrest him in Florida will stand trial in May. Marquis Floyd is accused of fatally shooting his ex-girlfriend, Sade Dixon, on December 10, 2016, before shooting Orlando Police Lieutenant Deborah Clayton when she tried to arrest him in January 2017. Lloyd reportedly lost the use of one of his eyes while being apprehended by authorities, claiming he suffered an unprovoked police attack. Lloyd now faces the death penalty. The trial of Pan Hupp, the woman accused of killing a mentally disabled man in Missouri to cover up another murder in 2011, is set to begin in June. Prosecutors claim Hupp fatally shot 33-year-old Louis Gumpenberger to divert attention for the murder of Betsy Faria, whose husband, Russ Faria, she framed for the killing in 2011. Hupp was the star witness in Faria's first murder trial, resulting in a guilty verdict. Faria was later acquitted during a second trial. Hupp now faces a charge of first-degree murder for Gumpenberger's killing. The two suspects, accused of killing a Florida State law professor in a murder-for-hire plot in 2014, will face a jury in June 2019. The suspects, Sigfredo Garcia and Catherine Magbanua, reportedly hired a hitman, Luis Rivera, who allegedly drove from Miami to Tallahassee and fatally shot Dan Markle. Rivera took a plea deal to a lesser charge of second-degree murder in exchange for his testimony against Garcia and Magbanua. Investigators believe the suspects were hired by Markle's ex-wife's family to kill Markle over a custody dispute, but no family members have been charged. The suspects now face charges of first-degree murder, conspiracy to commit murder, and solicitation of murder. The ex-wife of NBA star Lorenzo Wright is set to stand trial for his murder in November 2019. Shira Wright and her cousin, Billy Turner, are accused of conspiring to kill Wright in 2010 when Wright's body was found with multiple gunshot wounds in Tennessee. The pair allegedly had a co-conspirator, Wright's cousin, convicted killer Jimmy Martin, who allegedly assisted with the cleanup of the crime scene. Martin turned state's witness, leading investigators to the murder weapon, which was tossed in a lake in Walnut, Michigan. Wright now faces a charge of first-degree murder, but won't face the death penalty if convicted. I'm Anthony Velez for Law and Crime, and those were the top upcoming trials of 2019.
Thank you, Anthony Velez, for summarizing those cases. We're going to be following them here on Law and Crime and hope that you'll join us. Now, one of the themes that we see run throughout trials of 2018, but also into 2019, is those where you hear that a defendant has either been declared incompetent to stand trial, not go to trial, or they are in trial and they are claiming the insanity defense. So thankfully, Elura Nanos is my expert who's here who can talk to us about what is the basic difference between whether or not they're competent to either go to trial or they go to trial and then say, oh, insanity defense.
So they're different in terms of what is necessary to prove. They're also different in terms of the goal of proving it. So if we're talking about competency to stand trial, we are talking about a judgment that's made before any trial happens. And the whole concept there is to say this person has some type of mental problem, and that problem is going to prevent the person from actively contributing to their own defense and cooperating and understanding the proceedings. So therefore, basically, we shouldn't even have a trial because that's not really going to work for this person because this person has such a severe mental problem. On the other hand, not guilty by reason of insanity is a defense such that now the person generally doesn't get to just go home after they have successfully proven that they were not guilty by reason of insanity. This is something that happens during a trial as a defense, so the trial is going on and the person's response is at the time the crime was committed, not before and not at the trial, but at the time the crime was committed, there was some kind of mental problem going on, and that mental problem contributed to the commission of the crime. And the standard differs from state to state.
Okay. So let me just say, so the Uber driver, for instance, they've already said, nope, he's competent. He doesn't have a mental defect that affects him all the time. That means he can't contribute to his defense.
Yeah.
He's okay now. But they've already said he's likely to raise the insanity defense, meaning at the time it happened, he was on some illusion or something was amiss and he couldn't understand the consequences of what he was doing. Is that right?
That's exactly right. And I think a case like the Uber driver is a very good example of what can happen with an insanity defense, because he's okay now, he can stand trial now. At that trial, he may bring up that at the exact moment that this crime was committed, he was at that moment suffering from some type of mental defect that contributed to him committing that crime, and maybe it's enough to get a not guilty verdict by reason of insanity. If we get that verdict, though, what happens next? The question will be, does he need to be in some kind of mental institution, or has the mental issue been resolved so that then he actually can re-enter the public? That's something that's going to be really, that's really where the meat of the insanity defense comes in, for what happens at the end.
So this is going to be an interesting year in trials, because I suspect we're going to see that in a number of cases. The other issue we're going to see is Miranda warnings and rights, and whether or not they were properly given to defendants prior to them making a confession in a case. And there are a few cases in which the court ruled, nope, wasn't proper. So we are going to take a break, but please join us back 1:30 Eastern Standard Time. We'll go back to the live trial that is our first of 2019. Welcome back to Law and Crime. So, you know, one of the reasons I love being at Law and Crime is because we show you the current live trials so we can learn about our justice system and also talk about other ways to prevent some of the horrific crimes that we cover. However, having said that, the top court moments of 2018 also show us that you never really know what to expect in court. Let's watch.
I'm Anthony Velez for Law and Crime, and here are your top 5 caught on court camera moments of 2018. Number 5.
God! God! God!
A suspect in a double murder was denied bond in a Florida courtroom after screaming from a wheelchair during his bond hearing. 19-year-old Damon Kemp is accused of the fatal shooting of 19-year-old Trey Ingraham and 19-year-old Jordan Payton at their home in Daytona Beach. Kemp, who was reportedly staying with the two victims at their home, is seen being disruptive during his bond hearing.
God! God! God!
I've reviewed your arrest warrant to determine whether there's probable cause for your arrest.
That?
Kemp now faces 2 counts of second-degree murder. Number 4. A crazy melee unfolded in a Florida courtroom after a guilty verdict was read in a murder trial. Video shows the eruption of violence after the verdict was delivered in a murder trial with 4 defendants. 3 of the co-defendants can be seen brawling with their own defense attorneys and court bailiffs. Once order was restored to the court, all 4 defendants were sentenced to life in prison. The 4 men were convicted in the shooting death of 28-year-old Courtney London in 2016. Number 3. A man in Oregon was caught on camera trying to grab an officer's service weapon during his trial in a Lincoln County courtroom. 27-year-old Scott Patrick Lemon can be seen quickly standing up and unsuccessfully lunging for the gun of a Newport police officer before being tackled to the ground by another officer. Lemon was convicted for robbing 2 guests at a beachfront condo in Newport with a fake gun. Number 2. A judge in Washington state played the role of court officer and chased down 2 handcuffed inmates who made a run for sweet freedom in his courtroom. The inmates, 22-year-old Tanner Jacobson and 28-year-old Cody Howard, saw an opportunity to escape and went for it. That's when Judge R.W. Buzzard surprised everyone and leapt into action, chasing down the fleeing inmates. Buzzard was able to apprehend Howard before he exited the building. Jacobson was caught by officers a few blocks away. Here's the number 1 caught on court camera moment.
We, the jury, find the defendant Daniel Villegas not guilty of...
Daniel Villegas was found not guilty of murder, ending a 25-year saga that included 3 trials and appeals. Villegas faced capital murder charges for the 1993 fatal shooting of 2 teens in El Paso and served 18 years in prison prior to his acquittal. Villegas, who was 16 at the time of the killings, faced his first trial in 1994, which ended in a mistrial, but was convicted during a second trial a year later, receiving a life sentence. The bittersweet moment of his acquittal was caught on court camera.
We, the jury, find the defendant, Daniel Villegas, not guilty of...
That was the #1 caught on court camera moment. I'm Anthony Velez for Law and Crime.
Yeah, again, you never know what's going to happen in court. Do any of these moments surprise you, Elura, that you just watch some of these defendants falling out?
No, you know, they really don't, because when I was a prosecutor, I remember that really anything could happen in court. And the moment that always sticks out for me is that there was a time I was in family court, and it was a juvenile prosecution of a 15-year-old girl who was a very small little girl, seemed relatively calm. And in the middle of her trial, she went absolutely crazy and lunged after the court officers and tried to grab their guns. And it was totally shocking. And I mean, you know, live court, literally anything could happen. It's such a pressure cooker in there that, you know, you just never know what's going to happen.
That's right. That is absolutely right. So we are now going to turn our attention to a case that we've covered here on Law and Crime. It's Florida versus James Colley. You might ask, why are we covering this case now while we're on a lunch break in the live trial? Because the similarities are a little frightening, to be quite honest, because in James Colley, he too went after an estranged wife. And in both of the cases, Colley that we covered previously, as well as the new 2019 case of New Jersey versus Jeremiah Monell, both of the wives in those cases had restraining orders out against their husbands, the very men who stand accused of these crimes. So we're going to go now to the prosecution, and let's see what they say happened in the Florida case from 2018.
Fucking disgusting. That's what you are. Call me, or I'm going to come find you. Fucking whore. These are some of the last words Amanda Colley heard from her estranged husband on the morning she was murdered. Words sent in voicemails, threats sent over text message, and words yelled at her as she was shot and murdered on her bathroom floor. Murdered after she heard the defendant go into her bathroom closet and shoot at one of her friends. It turned out to be her best friend, Lindy Dobbins. Lindy had been hiding in the closet, crouched down behind a chest of drawers. She was on the phone with 911, and she died with the phone still up to her ear. You will hear several 911 calls in this case, 2 of which capture the homicides on open lines. Both Amanda Colley and Lindy Dobbins called 911 just seconds before they were murdered. Those calls connected seconds apart, and they allow you to hear and witness just at least a part of what happened in the house that day that brought us here today. Amanda's call connects first, and it begins with her pleading with the defendant. You will hear her say, "He's not in there. He's not in there. Please stop." She's referring to a man named Lamar Dubberly, who the defendant was there to hunt down and kill. Lindy's call connects just 14 seconds later, after Amanda's, and it begins with her screaming, "Oh my God, oh my God, I've just been shot. I've just been shot." You will learn that that was a shot that came through the closet door, grazed the arm of another friend and witness you will hear from, Rachel, and entered Lindy's foot at the back of the closet. She kept screaming, "Lindy, until the defendant walked into the closet, gun in his hand, pointed it at her head, and killed her. Shot her in the head and shot her in the shoulder, just inches below the head. These murders occurred August 27th, 2015, in the neighborhood of Marabella, which is in the Rural Golf Village area here in St. Johns County. It was just after 10:30 a.m. when the defendant, estranged from his wife and not allowed to have contact with her and not allowed to be within 500 feet of the home on Bellagio due to an injunction, committed these murders. Amanda Colley and Lindy Dobbins were not the only two individuals in the house that morning. Amanda's other friend, who I mentioned, Rachel Hendricks, was there, and a man Amanda was seeing, Lamar Dubberly, was also present. Rachel and Lamar lived. They escaped the defendant's attempts to kill them, and they will be here to testify and tell you exactly what they saw and what they heard that morning. In order to understand what was going on
It is a frightening scene as described by the prosecutor in opening statement in the James Colley case, and that was a Florida case in 2018. And again, we're looking at the similarities, frightening similarities, to use the same word, between that case and the current case that we're covering live, New Jersey versus Jeremiah Monell. Elura, let me ask you, in both cases, we know it's estranged wives. They each had a restraining order against their husbands. How much does domestic violence come into these kinds of cases between two individuals in a relationship?
Domestic violence is everything when it comes to violent crimes. Now, while not every single defendant and victim had a history of domestic violence, so many of them did. An overwhelming percentage of crimes committed by one family member against another are situations where there was a history of domestic violence. And let's keep in mind, it's when we say, oh, well, this person had gone to court before and sought an order of protection, as what happened in the Colley case. To get an order of protection, a person has to be able to prove to some degree to the judge that there was some history of violence or threats of violence. So none of this is surprising, and it is why reporting domestic violence in any amount, in any frequency, is so important.
And so the restraining order, we've talked about it, and I've covered trials on this show before, to say a restraining order is only a piece of paper, but it's the right thing to do because it's a piece of paper that allows you to call the police and say he's too close to me or he's threatening me, and they can then arrest him for that, for violating that order. Is that right?
That's exactly right. And I'll even go a step further. In order to obtain a protective order, it means that a victim of violence has to go forth and tell his or her story. And for so many victims, that's the part that's difficult. That very first step to articulate, I am being victimized right now. And establishing that rapport with the court, establishing that rapport with the police department is an incredibly important step, hopefully to preventing at least some incidents of domestic violence.
And I think it's a brave step because, like
Absolutely.
you said, so many victims, it's very hard to come forward, to say anything, to do anything. And I just want to emphasize, regardless of the outcomes in these cases or allegations that they've been murdered and been a victim of domestic violence, there's absolutely no reason in the world why a victim should not feel compelled to speak out to protect themselves, to get a protective order.
Absolutely.
All right. So we are going to go to a short break, but we will be coming back. Just a reminder, we're covering live New Jersey versus Jeremiah Monell. That case is in a lunch recess until 1:30 Eastern Standard Time. Please come back after this short break. Welcome back to Law and Crime. We are going to continue to look at similarities between a 2018 trial, Florida versus James Colley, and the 2019 trial that we are covering live here on Law and Crime. We've talked about some of the similarities. Here's another similarity. There were surviving victims in both cases. So first, let's look at the surviving witness in Florida versus James Colley, Rachel Hendricks, who was a friend of the woman who was murdered.
What room in the house is this?
The master bedroom.
And is this closed?
Saying, open the door, and going to shoot. So he shot through the door where I was standing. The bullet grazed my arm. So I backed off, and the door banged up against me in the closet.
Okay. And you see the photographs that are depicted here on the screen, slide L. This is inside the closet looking at the door, correct?
Yes.
So, you're standing just there on the inside of the door?
Yes.
And so that shot comes through the door, and you actually feel it. You see it. Like you said, it grazed your arm.
It grazed my arm. I felt it. It was like a rubber.
And what happens next?
The door came in on me. I backed up and let the door come in on me. And Mr. Colley walked past the door straight over to Amanda. To Lindy, who was kneeling down. Heard Lindy say, "Oh my God, no!" And I ran out of the closet and heard a shot and ran out the front doors of the home.
So I can only imagine what it would be like to survive such an attack and you see your friend murdered. Now, the live trial that we're covering is a little bit different because the surviving victim is a 12-year-old. A 12-year-old who woke up because of his mother banging, not his mother, I'm sorry, the victim in the case who's now deceased, banging on the floor. That woke him up. So let me ask you, as a former prosecutor, what's the difference to you in questioning an adult victim who survived and has to recount the story versus questioning a 12-year-old who may have witnessed a crime and has to testify?
Well, there are a lot of differences there. For starters, children generally are difficult as witnesses because they tend to be more afraid, less understanding of the procedure. Obviously, a 12-year-old is going to probably be even more traumatized, not to minimize the adult's trauma of being in that situation. So I think that it's difficult to have a child on the stand because the entire concept of speaking in public, testifying about something so emotional, is going to probably be harder on a child. On the other hand, though, every word a child says on the stand is going to have potential to be more impactful to a jury just because it was spoken by a child. When children testify, there's almost no inkling in anyone's mind that the child might be lying. Cross-examination is done much more gently because no one on any side wants to further traumatize a child. So it's a complex and nuanced difference. And the biggest one is that we tend not to prepare children witnesses as much because then it has a bad impact on the testimony and can make it stale and seem coached. And that leaves the door open for sort of almost anything happening while the child is on the stand.
Okay, so let's continue to watch this victim's testimony again, the adult surviving victim in the James Colley case, and let's see how her testimony indicates if she was traumatized or not and whether or not she sounds coached. All right, so here we have questioning, and let me just ask you, Elura, they're doing a lot of questioning about pictures that he is identifying as the mobile home and both doors to the mobile home. How is that significant as to what happened in the mobile home?
Well, anytime we have an eyewitness to a crime, where we know that what's going to come is that someone is going to tell a story about what happened, which is what we're expecting from this 12-year-old, it's going to be important to kind of set the groundwork for what does the structure look like and what room is where and how is it all set up so that later we don't have to ask the person telling this very dramatic story to also create the scene. So this is just groundwork so that the jurors can then understand if a witness says, well, I was in the kitchen and this person was there or whatever, that we can understand what it looked like, how everything was set up to kind of make things go smoothly later.
All right, so it sets the stage, so to speak, for everything else that happens?
Yes, and we want that stuff to be brought in under the testimony of a police officer, because it's not that interesting. You know, it's necessary, but it's not really that exciting. So we don't want to waste the drama of an eyewitness to tell us, you know, how the rooms are set up, because that stuff's got to get in there. But it's better to have the professional testify to that. You know, the police officer has probably testified a ton of times. He knows how to get this out quickly and easily and clearly and succinctly, so that now the juror knows, okay, I get it. I get what everything looks like. Later, when we hear this very dramatic story, we're already going to have an impression of what it looked like.
And is there any chance that they may ask to actually go to the mobile home, to the scene with the jury, so the jury can see firsthand the scene where the murder or alleged murder occurred?
Yeah, I mean, there's always a chance the jury can ask to do that. I'm not sure at this point if that's in the plan for this case. I'm fairly certain that that is what the jury did in another New Jersey trial. We had the David Criado case. That they did go and see the location. We'll have to see if that happens in this case.
All right, stay tuned. We're going to take a break and then return to trial in this case. All right, it looks like they're having a sidebar. And again, this is Sergeant Dehart with the New Jersey Police, and he responded to the call of a white female who was deceased, and he's describing the scene when he got there. So let's talk about, you already said he's setting the stage, telling us what it looks like. We don't know whether or not they're going to go to the scene with the jury. But in your experience, in your opinion, how effective is it, or how necessary is it to actually go to the scene to find an alleged or a defendant accused of murder guilty beyond a reasonable doubt?
It's not necessary, and it doesn't happen in most cases. I do think, and you know, one of the trials we covered early on in the Law and Crime Network's days was a case where a young child was found dead near a lake or in a lake, and it was actually really helpful, I think, for the jury to see that, because the defense was that the child got there accidentally and that it wasn't a murder at all and that he just wandered there. So in that situation, it was actually really critical for the jury to see, like, how likely could it have been that a child would have stumbled there? And I think it created context. In a situation where there's an eyewitness to someone being stabbed 48 times, I don't know that it matters. I don't know that it matters where it happened. I don't know that it matters what it looked like. The only thing that matters is whether or not you believe the eyewitness account.
So let's talk about that. We've talked about it on a break. There are a lot of resources that go into a criminal trial. I mean, a lot of money, a lot of time, a lot of resources. Yeah. In this case, do you think it's a waste of resources? I know he has a presumption of innocence. That's a constitutional right. But listen to the evidence and what they expected to show. Is this a waste of resources?
I do think it's a waste of resources. And it makes me angry, because to me, what this is a man who has a history of being an abuser, being a criminal, being violent, and trying to control everyone and everything around him, now trying to control his fate in terms of answering for those crimes. It's very typical. Of course, I have a great belief and faith in the criminal justice system, and it's, of course, a very important aspect of our American government. But in this particular case, where this guy was offered a plea deal of 30 years, he should have taken it, because it's highly unlikely that he's going to get acquitted in this case, because there's an eyewitness. That's not always the case. There are lots of cases where a jury really needs to sift through that evidence. In this case, I think it's so unlikely that he'll be acquitted, that this is just this guy's last way of trying to control things. We saw it in him refusing to come out. We saw it in him complaining about his attorney. And this is just a further manifestation of his psyche.
All right, so let's talk about, in New Jersey, he did pass on a plea where he would have 30 years. Now, I think that what he's facing is life in prison without possibility of parole if, in fact, he's convicted of murder.
Right.
So tell me about New Jersey. It's my understanding New Jersey does not have the death penalty.
That's right.
And so life in prison is what, for capital punishment, is going to be. And that's what he faces now. So
right. And he's young. So, I mean, had he taken that plea, he might have gotten out and had some years left of his life. If he gets convicted now, that's off the table.
All right, so let's talk a little bit about what we know now about why he refused to come in the courtroom this morning. He did refuse to come into the courtroom, and the judge said, we're going to proceed with trial whether you come in or not. Apparently, there was a bailiff that was walking quite a bit, and he said, listen, it's adding to my anxiety, it's making me anxious, and that's why he didn't want to come in the courtroom. However, he did end up coming in the courtroom, and he's there. Let's see what's happening next in court. They're taking another sidebar. So we're not sure what's going on at those sidebars. If and when we learn, we certainly will report it to you. So let's talk a little bit again just about resources and use of resources on this case. One thing I note is the prosecution, though, if they're going to trial, they're going to trial. And so far they're starting with that first step to lay out the foundation of the scene before they go to the next witnesses. I think that's necessary. Are there any shortcuts they can afford to take?
I really don't think so. And you know, the stakes are so high here. So of course they're not going to cut any corners, and I would expect that in addition to various investigators, we're going to hear from medical examiners, we're going to hear from experts, we're going to hear from anyone that had contact with this child, both the neighbor and you know any official people, investigators that maybe were involved. So I mean, I expect a lot of witnesses before we get to the ones that were there at the scene of the crime. We may hear some background about past domestic violence between these people. So, you know, I expect that it's going to be a fairly long trial, and that, you know, we're going to hear, there's going to be lots of evidence. So like you said, you know, the prosecution, they're not going to cut corners just because, you know, it may be wasteful in the sense that this guy really should have taken a plea.
And, you know, I'm just going to assume that the defense, too, is really going to do everything they can, make every possible argument, especially given they know they have a belligerent client. They know that he is frustrated with them, not happy with the testimony, not happy with what they're doing. So I just have to feel like they're going to do everything that they can. But before we return to that discussion, we're going to go back to court where he continues to testify. All right, so this is testimony being offered by the sergeant that was one of the first New Jersey police to arrive on the scene after the initial first responders, and he has described at length what he saw, pictures of the mobile home, diagrams of the inside. Now he's talking about, and this is going to get interesting to hear about what potential witnesses we're going to hear from, because he testifies that he, along with one other law enforcement, interviewed Crystal Greer, Joshua Monell, who's the brother of the defendant, the father of the defendant, Edward Monell, and some others. So there's going to be a lot to hear about. Now there's a sidebar, and there have been a number of sidebars. Again, we don't yet know what those are about during this witness's testimony. But do you have any guesses? What would you say they continue to approach and have sidebars throughout this testimony? Any ideas of what maybe the defense or prosecution's talking about?
I mean, I imagine that it has to do with some kind of technical evidence rule, because because the other ideas are not available, because this is a professional witness, this is a police officer, so I don't expect anything that's really personal to him as a witness. It's likely some kind of sidebar about the scope of what he's testifying about, or you know, maybe something having to do with like an evidence stipulation that the two sides came to before the trial, and maybe now he's testifying outside the scope of what they agreed to.
And I've noticed the prosecution's been pretty good about doing things like, for instance, okay, did you have a conversation? Don't tell me what they said, but after you had that conversation, did you enter the home? So they've avoided things like hearsay and some of those objections. Is there anything that you've heard him say in his testimony yet that you think isn't admissible, or that he shouldn't have been allowed to testify to?
Nothing comes to mind. I mean, he's testifying just about the logistics, about what happened that night, why he went to the scene. I'm really not seeing anything that is raising any particular red flags to me, which is why I'm thinking that the objection doesn't have to do with the witness necessarily breaking any rule or the questions being improper, but rather maybe his testimony exceeding the scope of what they already agreed to.
Right. And so what is the next step? It's interesting. They've jumped from the scene to 2 weeks out when he was notified that they found the defendant's vehicle in the woods, and he was notified of that. So, you know, it's kind of, here's the scene, the defendant disappears, and then they find him 2 weeks later. Does the prosecution or defense have to focus on that 2 week period, or can that just be kind of a nothing happened then we found him and picked back up?
Well, they don't have to, but I think what they're doing is very smart, which is that they're going to try to tell the story of the crime, which is going to be what happened on that night, and then what happened once they found the defendant. And then later, maybe we'll as like sort of a separate matter, we'll talk about, well, what were you doing in those 2 weeks? were you running away because you committed the crime? It's almost like that's like a diversion in the story, and I think actually it's smart for them to do it that way.
All right, so let's do a recap of where we are today in this live trial. This is, again, New Jersey versus Jeremiah Monell. He is accused of killing his estranged wife. Friends state that he'd been physically abusing her for about a 10-year period. She did have a restraining order. She was stabbed to death in her home. The 12-year-old and 5-year-old, 2 children were present, and the 12-year-old said that he was awoken during the night when he heard a bang, and he then, according to the prosecution's opening statement, states that he saw the father stab the mother over and over again. So we're going to watch this entirety of this trial here live on Law and Crime to see what the evidence does show. It's going to be an interesting case because the father, quite frankly, in this case, the accused murderer, has been very belligerent. We are going to take a break. Please come back, and we will be signing off with a new host at 3 o'clock. Heather Hansen will be joining. Come right back to Law and Crime.